Today we are going to talk about the legal risks and the best practices that organizations should adopt when they are transferring their employees' data outside the country, outside of your national boundary. Welcome to my YouTube channel where you daily see new content on privacy, and as we are talking about the employee privacy these days, let's talk about the cross-border data transfer also. Is it really required? It is. In most of the cases, the employee data definitely goes out of the country in the modern days. Why does this happen? This happens for a few very critical functions, like for example payroll processing. You have outsourced payroll processing and you are using an international processor. It's faster, it's better service, the HRMS software has better features. So you are using an international product, either using it or taking some consultancy or subcontracting them. Your internal mobility. Yes, you see a lot of companies these days who are multinationals. So there is a mobility possible. You would share their information to your global subsidiaries, maybe to your global head offices. You would relocate them for permanent job assignment, maybe for individual project assignments. Every time that is going to happen, personal information of employee is going to be shared. Right? His name, his address, his phone number, his family contact details in country, his banking information in country, his provident fund information in country. These are going to be shared even if you are just sending him for a project assignment for 3 to 6 months assignment also. Global HRMS, we spoke on the first point also that you might be using an international HRMS for better features, better scalability, whatever could be the reason, and there are two things here. A, the software is international. B, the data is also kept on the international servers and not on your local servers. Right? The service provider is also global. And you want to utilize the centralized benefits of insurance companies, retirement plans. This is largely applicable to multinational companies. Even if it's an Indian multinational, your company might feel that the insurance policy being provided by an international provider is better or gives better benefits. Even if it's optional, not all employees choose it, but even if one chooses, then you have to be prepared for sharing his data across the border. What are the risks involved? Is that country having adequate protection with respect to privacy? Are they having rules and laws? If not, what is the possibility of misuse there? So we've been talking about this earlier also. Are the transmission lines good enough that the data cannot break down? Are you sending encrypted and anonymized data, or is it just plain data which can be easily hacked? And does that country follow any standards with respect to privacy? Are your employees aware that their data is being transferred? Most of the regulators want you to take consent for every activity. So do you have a consent that their data they are okay with data getting transferred internationally? Is there transparency in that process? Are there any risk of breach from that point of view? Is there a legal basis of transferring this data? If not, then you are subject to regulatory penalties. So you need to be careful about it. And finally, are you transferring it to a sub-processor? Because the moment you say sub-processor, that means it is not only an international country, it is out of your organization. Right? So now two compliances are there. One is the cross-border and second is the vendor compliance. And you need to be careful of both of them and take care of the shadow data also. Which means that while you believe that you don't have any extra copies of data, but that subcontractor might be keeping some copies with him even after the end of the contract without your own awareness. So be careful about it. What are the legal requirements? As I mentioned, all regulators need at least a consent. GDPR has its own way of handling it. GDPR asks you to sign standard contractual clauses, SCCs, binding corporate rules. SCCs, if you are transferring it to any other company other than your own company internationally, so European data going out of Europe to a different company, is standard contractual clause applicable there. Binding corporate rules is a framework that any corporate has to adopt if they are transferring their employees' data or any personal information of their customers and associates from a European office to a non-European office. And they need the employee consent. Consent is a very, very basic thing when it comes to privacy. DPDP Act, though not fully implemented, not even rules finalized yet, but as of now it says that you are allowed to transfer data internationally only to a list of approved countries, and therefore you need a government approval if you want to transfer data outside India for any of your employees, even otherwise the cross-border data transfer outside the country. Employees should be informed, and as I said earlier also, and for all international regulators, consent is something which is the basis of privacy and is basis of cross-border data transfer also. Best practices: perform regular transfer impact assessment. You need to check first, is the recipient country following any standards? Do they have laws with respect to privacy? What kind of medium is being used? What is the mode of transfer? Are you sending hard disks and pen drives through couriers, or are you transferring through internet, or are you having a dedicated lease line? And are you using encryption and anonymization to transfer your data? These are some of the components of transfer impact assessment that you should do before you actually start transferring data. And if there are any legal documentary requirements of your country or the other recipient country, then you should follow that at this stage itself. So you should sign appropriate agreements. Transparent to employees, free and explicit consent taken that is okay and allows you to transfer the data to another country. Minimize the data sharing, data minimization not in form of collection but in form of sharing now. And vendor due diligence if it's a third party vendor, because as I said earlier also, when you are talking of a subcontractor which is international, you are then going through two things. One, the cross-border data transfer. Second, vendor due diligence in respect of cross-border data transfer. Or optionally, you should try a local service provider, a local secure data storage. So these are some of the important things that you should follow as a best practice when you are trying or sending your data across the border. I hope you like the content of the video. I have a bit example also to make sure that you are able to understand it better. In a positive side, a European company is hosting the HRMS software. Not only the software but the data also with them, and you are using it. You are safe if you have done transfer impact assessment and signed the standard contractual clauses. On a negative side, if you are sharing CVs with a US-based consultant, you think he can give you better employment. You are exploring employment opportunities internationally, right? For your team. Maybe it could also be applicable for the recruiting companies who take the candidates' personal information as CVs and transfer them to the international consultants for international placements and don't sign a proper contract. Maybe not even a consent from the person whose information they are sharing internationally. So these are two examples of a positive and a negative side of cross-border data transfer. I hope you like the content of the video. Please press the bell and the like icon, subscribe to my channel and share your feedback in the comment section. Thank you.